You too. Court calls the case, People versus Kenneth Miller.
Miller. Mr. Miller, say your name for the record, please.
Kenneth Miller.
Your Honor, today is the date and time set for sentencing. I do ask that the court adopt the majority of the sentence recommendation, with the exception of the SLAMS tether. We are asking for the court to consider ceasing that tether today. Mr. Miller, since this hearing or since this incident, did enroll in home division. He's been enrolled in home division for a couple months now. He did complete a parenting class through Orchard.
Right here, we see the defense painting a picture of genuine progress, highlighting parenting classes, substance abuse programs, CPS involvement, and victim impact participation. These are exactly the kinds of steps judges want to see, but they don't guarantee mercy. Many defendants assume that completing programs automatically reduces penalties, but that's not how the system works. Judges weigh these improvements against the original offense, the risk of reoffending, and the statutory guidelines. What's important here is the tone. The defense is emphasizing accountability and growth, but the judge is already signaling this isn't a minor case by legal definition. So here's the big question for you, Shud. The court lean heavier on rehabilitation or responsibility? Drop your opinion in the comments.
Orchard Children's Services, which is notated in the recommendation, that has since been completed. I did reach out to them for completion proof. I haven't received that yet, though. Mr. Miller also did complete the victim's impact panel. There was a CPS case that was open as part of this incident, and that case has since been closed. So Mr. Miller has completed some good stuff since this incident happened last year. He has obviously taken responsibility for what happened and is working to improve things.
This moment is a perfect example of how financial realities crash into courtroom expectations. The judge isn't just being tough, he's being realistic. A probation period comes with strict timelines, and fines must be paid within those boundaries. When Miller offers $50, the judge immediately sees the math that pace doesn't meet the court's requirements. But here's the twist. The judge also recognizes effort when Miller adjusts to $200 per month. Courts are often more flexible than people think, as long as the defendant shows seriousness and honesty. What would you do in that situation? Offer a number you hope works, or a number you can actually maintain? It's a high-pressure moment, and every dollar carries weight.
So given all of that, we are asking for that, but ask that you adopt the rest of the.
Are you saying he wants to do the 4 days?
He does not want to do the 4 days.
Okay, that's what I thought. Mr. Miller, anything you want to say before I impose sentence?
No, Your Honor.
Court does acknowledge this is not a serious misdemeanor as defined by statute. However, it does believe there are reasonable grounds to depart from the presumption of a non-probationary sentence. The alcohol screening assessment identifies the benefit of outpatient treatment and abstinence from all intoxicants. Therefore, the court will follow the recommendation of probation for a probationary sentence with the stated rehabilitative goals to promote change, prevent recidivism, and to monitor compliance of treatment. Therefore, the sentence of the court, you are placed on 24 months probation. You're to pay $1,055 fines and costs, $100 prosecution recovery costs, $100 police agency recovery costs, $720 probation oversight fees. When can you pay that?
I was hoping to set up a payment plan.
Do you have anything today?
I don't have anything today, but I will on Friday.
How much will you have on Friday?
I can put like $50 on Friday.
This will never get paid in 24 months if it's $50.
It won't be. I can do.
This is the emotional centerpiece of the entire hearing. The judge is no longer speaking as a legal authority. He's speaking as a human being who understands the level of trust placed in caregivers of vulnerable children. The emphasis here is powerful. A special needs child cannot defend themselves, may not fully understand what's happening, and relies entirely on adults to treat them with patience and compassion. When that trust is broken, the legal system reacts sharply. Notice how the judge highlights parental reliance, the child's vulnerability, and the moral responsibility of anyone working in that field. This isn't just a violation of LUTs, a violation of humanity. Do you think remorse and losing her job are enough to soften sentencing, or should consequences be firm when a defenseless child is harmed?
Like 200 a month.
Pay $50 this Friday, the 14th. And $200 per month beginning December.
Thank you.
There should be no use of alcohol, recreational marijuana, or any illegal substance. You'll be subject to random testing as requested by probation. You are to complete outpatient substance abuse treatment at home and revision, including all recommended aftercare with status reports to probation. You are to complete the parenting program through Orchard Children's Services with proof to probation. You're to provide proof of the victim's impact panel attendance to probation. I will continue the scram tether for an additional 30 days in lieu of 4 days in jail. I'll order 180 days in jail. Credit 1, the balance is suspended. Thank you.
Thank you.
Court does call the case of the people versus Diana Seaborn.
Good morning, Judge Simpson. Attorney Carl Jordan, P 57226, appearing on behalf of Ms. Deanna Seaborn, and Ms. Seaborn is present, Your Honor.
All right, go ahead.
First of all, Your Honor, I apologize for running late.
All right.
I know that the time was changed, but I was in another court. No excuses. I apologize.
All right, very good.
Your Honor, with respect to Ms. Seaborn, she did plead no. I did go over the PSI with her. There are no additions, deletions, or corrections made. I would just like to address what I believe would be an appropriate sentence.
Yeah, go ahead.
They are asking, Your Honor, for 29 days, 365, and I believe that they're asking for that to be held in abeyance, but that you serve 29 days. I don't believe, Your Honor, that would be appropriate. And I'm jumping straight to that aspect because, first of all, Ms. Seaborn is extremely remorseful for what happened. She did not give a statement because she was allowed to plead no contest due to civil liability. But make no mistake about it, she took her job seriously. She did not want to harm anyone, certainly not a special needs child. This is by no means an excuse, Your Honor. But when I asked her, why she may have done what she did, because she has no prior record, she said, being spat upon at that point, she just kind of lost it. But again, I am by no means saying that is an excuse, Your Honor, especially when you consider it was a child, and especially when you consider it was a special needs child. But I do want the court to know that had that not occurred, she would not be before any criminal judge, and I do not believe that she will be in front of any criminal judge in the future. She will complete probation successfully and go on and live her life. There have been some consequences. She did lose her job that she had as a result of these charges. So now she is doing DoorDash in addition to taking care of her sister. But again, she's sorry, she's remorseful, and she wants the court to know she has learned her lesson. Thank you, Your Honor.
Anything you want to say before I impose sentence?
No.
Well, I'm going to say this, counsel, and I appreciate the elocution. However, when I look at the circumstances of this case, this is a special needs child. Certainly, some things are going to occur. Certainly, it could maybe raise one's ire, but to do these things is, in my estimation, inexcusable. I mean, these parents, through each stage of a process on a day-to-day basis, entrust their child to these folks. And quite frankly, when you violate that trust, it's inexcusable in a lot of ways, in my mind. I mean, in particular.
And that brings both cases to a powerful close. In People v. Kenneth Miller, the judge balanced rehabilitation with accountability, eschewing probation, structured payments, treatment requirements, and maintaining the tether in lieu of jail. It's a classic example of the court rewarding effort while still enforcing responsibility. But the second case took a starkly different turn. When it comes to a caregiver harming a special needs child, The judge didn't hesitate. With strong moral reasoning, he imposed a 365-day jail sentence with 29 days to be served immediately, emphasizing the sanctity of trust and the vulnerability of the victim. These two cases reveal how sentencing isn't one size fits. It's shaped by impact, responsibility, and the deeper meaning behind each act. If you found these cases as intense and eye-opening as we did, hit that like button, share your thoughts in the comments, and don't forget to subscribe for more jaw-dropping courtroom breakdowns just like this one.
That this is a child that really cannot defend themselves if they even comprehend exactly what's happening to them. I mean, which just has to be sort of the worst thing. Was there a victim's impact statement? I was expecting that there might be.
I did not receive one, and I do not see the victims present.
All right. It is a sentence of the court. Place you on probation for a period of 60 months. You're to pay $655 fines and court costs, $1,800 probation oversight fees. When can that be paid?
You said 1,800, Your Honor?
Yes, that's what I have. Yeah, it's 60 months.
Your Honor, she realistically says that she can pay $150 a month.
Okay. $150 a month. That will begin in January 2026.
Thank you, Your Honor.
There's to be no use of alcohol, recreational marijuana, or any illegal substance. You'll be subject to random testing as requested by probation. You are to complete the Anchor Habits program. You're to complete 50 hours of community service. There's to be no contact with Elizabeth, Peter, or Eli Lorensky, if I'm pronouncing that last name correctly, that is directly or indirectly. You are not to be working with and or around any minor children. There's to be no assaultive, threatening, or intimidating behavior by you. You are not to possess any weapons, firearms, ammunition, or anything fashioned to be a weapon. You're to maintain employment with verification to probation. And let me just say this. Like I said, these parents entrust you. And, at no point, other than for the purposes of safety or other legitimate reasons, do you have the right to place your hands on that child? That's the only basis of you're trained, should have been trained, and I think you were, as to how to deal with these circumstances and these situations. You're having a bad day, losing control, and doing this kind of thing is never an option. And I understand counsel isn't saying it is an excuse, but it's not an option for you when you get into that role and in that circumstance. And so what I'm going to do is I'm going to order 365 days in jail. Give you credit for the 1 day that you serve. You will be remanded to serve an additional 29 days, and then the balance will be suspended. Defendant is remanded.
Your Honor, I spoke to my client about this, and she said, could she have time to get her affairs in order? And I said, well, really, what affairs do you need to get in order? I mean, the President of the United States could get his affairs in order probably quickly. And she said, I do have a daughter who's 14, and I wasn't expecting to have to serve any time because it wasn't part of the negotiations. May she have at least a few days so that she can arrange for a 14-year-old to go somewhere? She does have a sister, but her sister is the person that she takes care of. Her sister was shot. She's in the courtroom. So she truly does need to make provisions with respect to her daughter. And she understands if she...
At the moment this was happening with the child, was that child permitted to make any arrangements for their care? Probably not.
Of course not.
I will not pay her the same courtesy. Defendant's remanded. She'll go today.
Thank you, Your Honor.
Thank you.